Welcome to the Fearless Floyd Show. We'll begin in 2 minutes. Out of the way a little bit. Panel 2. 30 days to file a statement of intent. I have gone over the notice of intent and gave you an example of how to write one. The notice of intent has notified the court of our intent concerning the trust and what our intent is to handle this issue. The first filing with the court is only valid for 30 days and must be followed by the statement of interest if we are to take full control of the trust and issue the order to the court to handle this trust for us as trustees. Any comment on that?
Well, basically what they're saying is we are trustees. So we need to figure this out. And with this statement, we are giving our intentions and our interest in the trust. And we are literally giving up our position as a trustee to become a beneficiary. And that gives us the power to make the trustee handle the trust for our benefit.
Okay, all right. Okay, panel 3. There we go. Keep in mind, we are just going over the notices now and how you should be writing your notices to the court. There are a few other steps we need to complete during the 30 days after filing our first notice with the court. We will need to complete the UCC 1 by claiming the case and then a UCC 3 for assigning the case. We also need to create our own deposit receipt that will be filed with our statement of interest. We will cover all of this in the next documents. This document will only cover how we can write a statement of interest. Keep in mind, each person will have to draft their own statement of interest to tell the court what you want them to do.
You see, everybody's case is different. Everybody has a different will that they want. See, my will is not just to, recover the money. It basically is just to close out the case, let the court know that I'm not a child. I don't need their guardianship. And basically, I just want to settle this in a civilized manner, just to get it done and close it out. And basically, it's just, in my point of view, it's stopping them from continuing to tap into the bonds, because there's 3 bonds at the end of every court case. So it's just a blockage, just to get it to just stop and clear the record.
Right. Okay, moving on to panel 4. There are 19 of these. What is the statement of interest? The statement of interest is a statement for our trust we have recovered. In this statement, we must clearly identify who the parties are, who the parties of the trust are. We must name the grantor of the trust, and this is you. Now we must decide on who the trustees of the trust will be. You can continue on as a trustee if this is what you desire, or you can assign the judge and the district attorney or the district attorney as the trustees of this trust.
You see, there's a lot of benefits to continuing to be the trustee of the trust. And there's also a lot of benefits to be the beneficiary of the trust. And we're going to get into this in a little bit when we understand more about trust. So right now, this is sort of an overview of where we're going. And once we get through this and two other panels or 2 other presentations, we're going to get into about trust and how we're going to decide who we want to be in these court cases. So I'm just giving all the options right now of our choices and where we can go in the end, and what benefits we have if we stay as a trustee, and what benefits we have as a beneficiary.
All right. Panel 5. I personally like the idea of assigning 2 people as the trustees of the trust I am recovering. Let me explain why. First, if we just assign the judge, the district attorney gets off free and clear. Do you realize before the district attorney can try your case, they must file bonds with the court? The reason for this is if they make a mistake and take you to trial and you have a trust and you are working in the private, the court will dismiss the case and go after the district attorney. The bond is a guarantee that the district attorney has done his homework and is not trying the case in private, but instead in the public.
So you see, the judge is the one who's making the decision and who's creating the trust. And automatically, he's already given the district attorney and himself beneficiaries or the benefit of the trust. So we do know when a court case comes to court. I've never been to court really. I mean, I just had a small issue with my daughter in curfew when she was younger, but that was about it. That actually, in order to file cases like this, the district attorney is the one who files the cases and creates the case numbers. So why not just involve him too? Why just go after the judge? Why not go after both of them? That's my opinion.
In my humble opinion. All right, panel 6. By naming the district attorney as a trustee, we can order the district attorney to pay damages to the beneficiary for not doing his homework. What does this mean? We can take control of the bonds that are attached to the case. All the court cares about are the bid bonds, the performance bond, and the payment bond. This is where the money is. So by naming both the judge and the district attorney as your trustees, we have blocked these bonds and they cannot access them. We are controlling the bonds now, and we can tell the trustees who to pay with these bonds and how to use them.
So yeah, when the court case is filed, it's up to the district attorney's office to create these bonds and put the bonds inside the case. So they're always in the background. They're always going to be sitting in the background. And unless we close them out or we use them for our benefit, they're just going to be used for the court's benefit. They're the ones who are going to get the money. Even these court cases, seriously, if we lost the court case, the court doesn't really care about our case. Number one, it probably wouldn't even pay a month's rent or even a mortgage payment for the judge. What he's caring about is he's caring about those 3 bonds and how much interest he can draw off those bonds for as long as they stay open.
All right, we're going to move on to panel 7. Statement of interest example, and let me blow this up.
Okay, so this is similar to what we wrote yesterday. So basically, remember I talked about the road of passage? Okay, we have the road of passage here on this document also. This is where you put your certification sticker from your mailing onto the road of passage. The address is set up exactly like we set up the address yesterday, and we still write it night because this is how the Bible was written. If we want to do it in the day or we want to do it for the day, you change the wording to in the light of day instead of night. But it's better, I think, just to leave it at night because literally the world was created at night, or it doesn't really state when it was created, but it seems normal because when he said, let there be light, then there was light. So it was created in the dark, if you ask me, when it first was created. So until the light came about, there was no light. So it's better just to leave it at night. That's my opinion.
Right. Why it moved like that? Okay. All right. Number 8.
So we see the format that we used yesterday. It's exactly the same. We're addressing it to the judge, and we'll also address the second one to the district attorney. So we'll be doing 2 of them. The court case is on there, and this letter is, to whatever the judge's name is. You just change the verbiage on it to whatever the district attorney's name is, name of district attorney. We also have the social security number written 2 different ways because this is how it's formed on court cases. So we have to identify that in both places. And then down here, the other highlight we have is whatever the name of us, whatever our complete name is on the court case. And I identified the court case again and the base of the letter.
Okay. Y'all got that? We got it. Right. We're going to go over all these. We'll have all these. In fact, I'm sure you have these as templates, correct?
Oh, yes, these are templates. That's why I took pictures of them, because I didn't feel like writing the whole thing out on a screen. So basically,
Right.
I just took screenshots of it. That's why they're split up like this.
Well, when we walk through doing these, as we, go through the next step, then I was just going to put all my information on here, because my shit's already public anyway. I dare somebody fuck with it. Yeah, somebody when I was in prison, they were, somebody in administration that had access to our sensitive information sold a bunch of names and social security numbers. And they actually caught the guy and told me that my name had been part of an identity theft ring. I was like, oh, great. So,
Wow, did you benefit from it? Were you able
I
to tap
didn't
into
even
the
know about it.
benefits?
No, it sucked actually, because then you have zero credit. You start to put,
Ooh,
yeah, I mean, you can't, nobody will give you a credit card with zero credit. Nobody. Yeah, it sucked.
I guess they figured if you're going to be in prison for X number of years, why not sell it? Because, I mean, what is the thing? You have to spend 3/4 of the sentence in prison before they can even think about parole or something?
It depends on the severity of the offense, of the charged offense.
Oh, okay. Yeah, I don't know. I don't know too much about it.
If there's a deadly weapon, it can be anywhere from a third to a half in Texas. Just depends on some date circumstances. Old law, new law. Okay. Panel 9.
Okay, this is where the heart comes in. This is where I really changed a lot of it.
All right. Number 1, trust intent and purpose. The grantor of said trust name created by the name of court presiding judge name was established for John Henry Doe, grantor, by signature on the light of day, 16 July 2022, for the sole purpose to handle and discharging case number, whatever, trust property res, with said court. Said court presiding judge created the trust for the grantor. The grantor of said trust will take control of the express trust and assign the beneficiary and the duties of the trustees for said trust. The grantor of the trust is the only administrator of said trust and will administer said trust in accordance to trust laws. The sole purpose of said trust will be to pay any debt owed to the court through private credit and or private instruments. Once the debt has been settled at the court and the court bonds associated with said trust will be terminated and distributed. The court case will be deemed closed and settled, and no further action will be taken against this trust. Number 2, beneficiary and trustee assignment and duties. The trust name hereby assigns John Henry Doe as the sole beneficiary of said trust, whatever the trust name is. Hereby assigns the name of the judge and or name of the district attorney as trustees of said trust. This appointment shall remain in effect until further notice from the grantor of whatever the trust name is, bearing the autograph of the grantor and of the trust.
So basically here, what I've done is I've changed the verbiage of this to literally explain that this is our creation of our trust. This is being our express trust. This is the declaration that we are forming between us and the court, that we're declaring our trust. And down here, I'm assigning who the parties are of the trust. This is part of creating a trust.
Everybody's got to wear the right hat at the right time.
You can put as much verbiage in it as I do, or you can cut the verbiage down. This is all depending on you. I just like to cover all my bases.
Yeah, last thing you want to do is leave them a loophole to escape, because they will take it. They find it, they'll take it, and then some. All right, number 2,
Yeah.
beneficiary and trustee assignment and duties. Okay, it sounds familiar. The trust name, whatever it is, hereby assigns John Henry Doe as the sole beneficiary of said trust. The trust name hereby assigns the judge and or district attorney as the trustees of said trust. This appointment shall remain in effect until further notice from the grantor of the whatever the trust name is, bearing the autograph of the grantor of the trust. 2A, trustees' duties and assignment. Let it be known as of this date of filing, the grantor of the trust assigns the presiding judge, whatever his name is, and or the district attorney, whatever their name is, as the trustee of said trust with the following duties as assigned. Moving on to panel 11. Number 1, the trustees will manage the trust assets for the grantor of said trust. It is the trustee's responsibility to protect the property of said trust for the grantor and the beneficiaries of said trust. Number 2, the trustees hold the legal title to the trust property and will owe their fiduciary duties to the beneficiaries who hold equitable title to said trust. The 3 primary jobs of the trustees will include investment, administration, and distribution of funds to the beneficiaries. Number 3, the trustees are personally liable for a breach of his or her fiduciary duties. The fiduciary duties of the trustees include a duty of loyalty, a duty of prudence, and subsidiary duties. The trustees' duties of loyalty will require the trustees administer the trust solely in the interest of the beneficiaries. The trustees' duty of prudence will require each of the trustees to hold an objective standard of care in managing the trust property. Your subsidiary rules of said trust will include his or her duty of impartiality, the duty not to commingle trust property, and the personal property of each trustee. Each of the trustees will have these duties to share equally, or the trust will become passive and legal title will pass to the beneficiary of said trust.
See, I'm trying to literally lay these out so that there is no question as what their duties are. People have gone into court and they've used these letters in the past and they said, well, the judge hasn't, filled the duties of his job, this, that, or something else. Well, a lot of people forget that judges or trustees can only do what the trust says. So if it doesn't lay out every single little bitty piece of the trust of what needs to be done, they're not going to do it. That's the end of the story. So I try to really make sure that I get everything in there that needs to be in there. And you guys need to sit down and make a list of everything that you want them to do and to follow to an order or to a T. And before you even start writing your letters.
All right, moving on to panel 12. Number 3, mission objective. 3A, this notice serves as the acceptance to the appointment of the beneficiary and trustees of John Henry Doe Trust as in accord with the will of the grantor to administer the distribution of the assets, credits, and interest, as well as to settle all claims against the trust. 3B, this further serves as notice of the grantor's trust intentions to maintain a peaceful relationship with those in care of persons serving as trustees, fiduciaries, and public servants appointed by the grantor to serve the interest of the trust. Number 4, execution for date. Execution for whatever date is for John Henry Doe Trust, a child of God, our creator, assumes the duties and guardian and trust executor for the estate. I'm sure there must be more.
Okay, here, this is basically just saying what our objectives are for our trust and how we're supposed to administer them and what our intentions are as a peaceful person and knowing who we are.
All right. Let me read that last one again. Execution for whatever date John Henry Doe Trust, a child of God, our creator, assumes the duties and guardian and trust executive for the estate and is granted full faith and credit to execute the duties of this office as is the will and testament of the grantor. Number 5, administration and logistics. 5A, claims against the trust. The names of the trustees of this trust will act as joint fiduciaries to protect the investment and distribution of the trust. Any claims made against this trust for payment or usage of credits or interest of any kind and in any amount, whether it be for tax or fee or collection or charges or discharge or court cases, shall not be paid without a full disclosure of charges presented to the trustees of this trust and approved by the grantor of the trust. The trustees of this trust are bound by their duty to protect this trust and only distribute funds from the trust to the beneficiary of this trust unless otherwise approved by the grantor of this trust. And that's throwing some hats around right there. 5B, when approval is given for the administration or probation of the trust, it shall be made evident in writing by the grantor as per requirement. Anyone who claims authority to act on behalf of the trust shall be required to be in possession of the letter affirming the fiduciary authority to do so. Continuing unauthorized use of credits or interest without express consent and upon being noticed by this order constitutes fraud against the trust and is the committing of perjury by the individuals acting.
You see, here we can limit the authority of trustees because sometimes trustees will overstep and say, oh, okay, this is in the benefit of the trust. I'm going to take, $5 million that's in this fund, and I'm going to go and I'm going to invest it over here because this is the interest of the trust. Or guess what? This person is saying that we need to pay this. So I'm just going to go ahead and pay it, even if I don't have to pay it. So this is one reason I'm limiting this. Now, if you knew the trustee, you don't do that. But if it's a court, you might want to add a little bit extra security inside your documents that you present to the courts.
All right. Okay. Okay. This is 5C, panel 14. Notice to fiduciaries. As fiduciary, you may not assert any management power over the trust without delegation in writing by authority and under signature of the grantor. Fiduciaries shall at no time improperly use the trust money, assets, property, services, or credit in the performance of or as a result of their official duties for activities that have not been approved by the grantor. 5D, notice to public officials. D1, every person who, under color of law or any statutes, ordinances, regulations, customs, or usage of any usage of any state or territory, interferes, obstructs, deprives any rights, privilege, or immunities of the trust shall be liable to the trust without immunity in any action at suit or other property proceeding for redress. Number 2, public officials wishing to present a claim against the trust shall, in accordance with the law and administrative policy established by the grantor, comply with requirement to disclose personal assets and liabilities, as well as those of their spouses and or dependents to the administration office of the estate.
See, we're protecting this trust, guys, because we do know that those three bonds that are in the back of the court cases have quite a bit of money on it. And we also are going to learn that trustees really have a lot of authority when it comes to trust. They literally have the right to sign all kinds of things. They have the right to create certificates, create payment bonds. They have a right to do anything. So in court cases, we want to try to limit the trustees, duties so that they don't go overboard in distributing the funds, and just literally stay on track and take care of the case only and not anything else.
Okay. Panel 15. 5E. Response is not required. However, any response received of which purports the inability or refusal to perform in accordance with the guidance set forth in this notice must be submitted to the grantor, including a signed PSQ1 or with affirmation signed under penalty of perjury in accordance with the requirements set forth in the Privacy Act of 1974, Public Law 93-579, which shall serve to ensure high standards of honesty, impartiality, character, and conduct as in accordance with Title V, CFT, Part 735. The trust is relying on your silence as consent and assent to bound unto this agreement and the duties and obligations set forth herein. In the testimony whereof, I have hereunto affixed my signatures of the trust on the night of 16 July 2022.
So basically, this is the last statement of the trust before we sign the trust. And it ends like it did yesterday. We're going to sign it as by grantor because we're the grantor of the trust. We're going to send it certified mail. But before we do all that, we're going to need to get our notary and get the certificates from our notary to send it in. These are all filed with the court because they all have to be entered into the case and sent to the judge for review.
Okay. Awesome. Well, I just got to notice my laptop is ready.
Oh, wonderful.
Well, we'll see.
Yeah, last time it got ready, it wasn't really ready, was it?
No, that was 5 more trips back to Best Buy, something stupid like that. Okay, this is the closing. Govern.
Yes, this is the closing. And I did on this one put a disclaimer for letting the court know that the reason I write the dates the way I do has nothing to do with anything. It doesn't, it's not biblical or whatever. It's just my choosing and how I choose to write the dates. Because if we do look at a lot of old documents, we will see dates written in a lot of different ways. And I just chose this format to write the date.
Okay. And 17.
That's our notary statement. It's done in black.
Okay. And 18. It's the summary. All right, here we go, kids. Summary. All notices will be written on legal size paper that is 8.5 by 14. It's the extra long paper. The trust notification and instructions are written in blue ink, which means you want your fonts to be blue. You want your wet ink to be blue because the document is signed in blue ink. We are creating a certified document each time we create a letter from the trust or even the executor's office. Depending on how we draft each letter will depend on how each letter is signed. For a court case, we are the grantor, so we must sign the letter as such with a period at the end of it. All right, and the last panel, kids. Drum roll, please.
Da-da-da-da.
The statement of interest is the instruction we are declaring as the grantor of the trust. In this letter, we are telling the court or even a loan company that we are the grantor, and these are the conditions of the trust they must follow. Here we can name as many beneficiaries or trustees as we want for this trust. We will make it very clear in this letter what our will is and how it will be carried out. If we say that no funds can be distributed from this account unless we approve them first, then this is how it is. The people we name as trustee must follow this to the letter, or they're in breach of their duties.
So basically, there you have it, guys. I've showed you the two letters, the letter of intent and the statement of interest. These are two letters that we're going to be using in our court cases to go over with the judge, to let the judge know, okay, we understand what you've just done to us. You summoned us into the courthouse. We did arrive at the courthouse, and in the summons, because you summoned us there, the trust was already automatically created. So we need to stand up and tell the judge, look, we see your trust and we understand how it works. And this is one thing that's good for us, because once we get in chambers and that judge takes off that robe who's out in public, all things change, and they're willing to work with you, for what I understand. Don't get me wrong, I've never been in chambers with a judge before, so I don't know how it works. I'm just going by what all people have told me that have been in chambers with the judge once they've filed papers, or they've, submitted, letters to stop foreclosures, or
Right.
whatever they've done. So don't take my word for it. You might have to find out for yourself.
Yeah, well, probably will. All right. Well, that concludes part 6, kids. Thank you for hanging around after the show. I want to present to you Tailor Made Trust, featuring LeFlore's Trust Series, available at tailormadetrust.com, as well as the fearlessfloydshow.com store. Here are a handful of the available trusts that can be built, custom tailored to your needs and desires. 25 different trusts, plus the DNA trust addendum. And as always, LeFlore's classic trusts and ancillary classes, and also Ann's books on trust and specialty trust, which I also co-authored. If you'd like to get a class, a book, or have a trust custom built for you, always available at the fearlessfloydshow.com store. And I'll see you in the next show. Thank you for watching, and have an awesome day.